Good afternoon, everyone, and welcome. I'm really excited to have this conversation today about AI. And the topic of today's session is AI policy a privacy issue? Joining us, we have our original provocateur, Omer Tene, whose blog post about AI policy and privacy sparked this idea for this session. Omer is a partner at Goodwin and formerly a professor, also affiliated with the Future of Privacy Forum, and was for many years at IAPP, the International Association of Privacy Professionals. Brenda Leong is at BNH.AI. She also was at the Future of Privacy Forum and is a leading AI expert and the one I go to when I have questions and things I want to discuss about AI. So I'm really delighted to have both of you here today to join me in this great discussion. So I'd like to kick it off by mentioning a little bit about what Omer said, and then asking Omer to elaborate a little bit on it. And basically, I'll paraphrase a little bit. In his post, he said that AI involves a lot of issues. Many of those issues are not necessarily privacy issues. And, can we use the same tools that we use for privacy? Are they going to work with AI? Is AI something that should be an issue that privacy officers, data protection officers are dealing with? And he was skeptical about whether or not AI just should be kind of one of the portfolio of privacy issues. But I'll let Omer elaborate on that a little bit more about what he meant there, and then we could discuss.
Yeah, thank you, Dan, and thanks for inviting me. A pleasure to be here, and a special pleasure to do this with Brenda. So, I think what I said or wrote wasn't really provocative or contentious at all. I think it's obvious and it's a fact that AI raises many issues, including legal and ethical issues that transcend privacy and data protection. To be clear, AI also in certain contexts does raise privacy issues whenever personal information is collected or used to train models or to personalize results. But by and large, AI raises issues that kind of range from human extinction, as some of the founders of the big AI companies noted themselves, to safety and trust and disinformation. There are security issues and IP issues. There are issues about labor market change and climate change. And I think it's obvious, and it shouldn't be contentious at all, that those issues aren't privacy issues. I think I'll start with that, and I'm assuming we'll have additional chances to talk about this.
Brenda, do you have any reactions?
It'd be a short webinar today if I didn't, right? So I agree in a sense that yes, that there's no argument about the fact that AI is a new technology, or is a new aspect of technology that is raising a lot of issues that we haven't had to face before. But I also think that there is, in fact, extensive overlap with privacy issues that have been raised, primarily because one of the primary things that powers AI is data, and one of the contentious areas of data is personal data, sensitive data. And because most of AI of the kinds that we're talking about here are the things that involve people's data, organizational data, institutional data, societal data, and how that's being used in ways that impact people as individuals and in groups and in societies. There's a lot of overlap, and there's a lot of reason to think that people with background and skills in privacy policy, data protection more broadly, since privacy really doesn't just mean a very narrow definition of privacy anymore, are going to be some of the leaders in figuring out how to start to address AI governance and AI policy as well. But definitely it is, there's no argument about the fact that there's more around AI that's going to have to be addressed, that it's not a Venn diagram of two overlapping circles directly on top of each other, but there is a significant amount of overlap. And I think primarily just from the fact that privacy professionals, privacy policymakers are used to thinking about data, used to thinking about jurisdictional issues and regulatory models based around a core set of principles, that is an approach that is very much already being taken and going to be taken in addressing the harms and issues around AI. And I think the last sort of point I would make in that opening section is that one of the reasons I think there is a lot of overlap and a lot of skills that are transferable between these two groups is that a lot of the harms are the same. Again, we're talking about AI in a lot of the contexts that impact individuals or groups, and a lot of the harms that we're looking at from that are very similar to or the same as a lot of the harms that we've worried about in privacy contexts, data contexts over the last 10, 15, 20 more years as those issues have developed. So in the interest of having a good engagement, I'll take that position of significant alignment, and we can go from there.
So maybe, Dan, if I can follow up quickly, I would say that I agree with a lot of what Brenda said, and I think we kind of expected that. But I also disagree with some of it. I think if you put it at kind of a high level of abstraction as a regulatory framework built in a set of principles, well, that applies to anything and everything. So I don't know if that's a helpful sort of framing to kind of, posit that AI policy and privacy policy are similar. Any policy is built on a set of principles and a regulatory framework that derives from that. I think part of the question here and the basis maybe for lack of full kind of understanding and agreement between Brenda and me, and I think others, it concerns the scoping, like the definition of AI. I think if you define AI to mean, technology that, algorithmic decision making based on personally identifiable information, then hell yeah, that's subject to privacy laws, and I deal with it every day. But I think AI means many other things. And for example, if we talk about autonomous vehicles, which are AIs, I think their main issue is safety and not killing people. And if you told me that, autonomous vehicle companies appointed the chief privacy officer as the head of AI, I would think it's strange. AIs mean military technologies that are actually deployed these very days in different battlefields. And again, I don't think that chief privacy officers are, so, maybe they want to expand their portfolio to tackle those issues, but I don't think it's currently in scope. Medical device manufacturer, even from a legal perspective, that's more usually of an FDI thing. It's medical licensing, and I don't think it's really for privacy. So I think you need to sort of look at the what do we define as AI? You need to look at the threat model, the risks. If the risk is disinformation and content moderation and sort of the threat of an avalanche or a blizzard of fake data that seems authentic, like we are facing right now, there are functions for that and have been functions for that in online platforms for many years. They haven't been necessarily part of the privacy function, although in certain companies they are. So I think it would help to scope what it is we're talking about.
So, yeah, I think that, if we're drawing a Venn diagram, there's AI issues that involve personal data and people. Those would be in the privacy realm. AI that could affect people in certain ways, which could then be a privacy issue if they're in ways that could invade people's privacy or affect people's autonomy. There are certainly ways that AI could affect people that might not really raise a privacy issue, like just safety in cars. So though could be that certain types of uses of AI could involve personal data or the way people drive that could share data, and that ultimately could involve privacy. So there's definitely a very complicated overlap, but there's overlap. But I think there's an interesting question of what exactly occurs in the overlap, and I'll put aside the question of what is AI, because the term is now used essentially to capture machine learning algorithms, and sometimes any other kind of algorithm is now called AI. But I think that we're going to need to have a little bit better use of our terms in the future. But right now we have this very large scale of what constitutes AI, and actually what I think a lot of what AI is today is actually not really intelligence. It's not really artificial intelligence. It's just an algorithm that simulates intelligence, but it's actually not technically AI as currently envisioned, such as these sentient robots who think for themselves and act for themselves. That's certainly not what we have today. But putting all that aside, let's look at the part of the Venn diagram where it does overlap with privacy and does involve privacy issues. There's still, I think, a really interesting question, which is that the appropriate area, or existing privacy laws, are they the right tool to address this? And I think that, right now, where privacy laws are, the answer is no. They're not quite able to address this. So I applaud efforts by the EU, for example, which is moving forward on a separate AI Act. I applaud that because the privacy laws as we have now, unfortunately, didn't listen to what many scholars had recommended. So early on, others, as well as me, had said that privacy laws were far too individualistic in focus. They were trying to give individuals control over their data, which was a laudable goal, but a goal that is just not really feasible. And I've written extensively on it, and others have written a lot on this. This is a common refrain in the scholarship, but the laws are kind of moving forward, and we're seeing that especially in the US with all the state laws, all about giving individuals rights and control and access and all this. And I think what AI is showing us is that just does not work, that things are so complex, and that the data is so interdependent, and that the issues transcend the individual. So I think that if perhaps policymakers had listened to what the chorus of scholarship was saying for so many years, for decades, that perhaps privacy laws would be better suited to address the problems of AI. But unfortunately, they did not do that. They pushed this individual control model, which unfortunately, and I think we're seeing, just does not work for AI. And so I think that what is good now is that we are seeing new efforts at legislation separate from privacy laws to push away from that model, And if you look at the new EU's AI Act, it's not really about individual rights. It's about risk, and it's focused on risks that various types of algorithms can pose. And so I'm curious what your reaction is to this. Do you think new laws are needed for AI, or do we need to adjust existing privacy laws to deal with this? And what do you generally think about the EU's effort and their model for addressing AI? And is this something that we should see, hope that would be replicated around the world, or do they have it wrong?
You want to start?
Sure, I'll jump in on that. I agree with a lot of what you just said, Dan, both as a sort of a commentary on the history of privacy laws and their approach, and where are we now and where do we go and how do we make that potentially work for AI laws. I think just to sort of follow up with these distinctions that we're making, one of the reasons that this doesn't translate directly across category to category is AI, as we've said, is a group of technology. It's a broad terminology for a group of technologies or ways of operating actual systems. Privacy is a value or a right. It's an underlying set of priorities for people. And so how we regulate those two things, or how we try to enhance and value that right in the context of these technologies that are being used, is going to be, complicated, is not going to be a direct translation from one to the other. So I think one of the lessons we can learn, hopefully, from, as you just sort of outlined, is that in the same way that this individual model of privacy protections didn't necessarily set the best precedent for us going forward, we may need to readdress how we do that. I also think that addressing AI in its entirety by saying AI laws, meaning laws that address AI or automated decision making as a whole, are also going to be less than ideal going forward. There are obviously a lot of similarities about the risks and harms created by any set of automated decision making tools, and those can be either replicated or generalized in legislation or in regulatory guidance in some ways. But because of the variety, and this goes back to what Omer's point was earlier, the variety of types of systems that rely on AI and the variety of contexts and implications and risks and all that kind of thing, I'm a little skeptical of the ability to sort of broadly legislate, here's a rule for AI. I do think that the EU AI Act has made a really good start, even using that approach, just in the fact that they are, as with many other things, sort of the first to try to put some words on paper, put a stake in the ground to say, here's our priorities, here's what we're trying to do, here's a way to do it. And they are embracing that risk-based approach that says, look at each system in context. What is the risk it creates? What are the primary concerns about that? How can we mitigate them? Is it so risky that we just shouldn't use it? Obviously, I could quibble about some of the choices they made or the way they did it, but it's hard to make laws. It's hard to make really specific laws where you go down to the detailed level and put something out there. And I applaud the fact that they're out there getting that done. I think there's going to be a lot to be learned from that process, just like there was from GDPR. And as they sort of set the standard moving forward with that. But again, I'm a little skeptical of whether that's going to be the ultimately successful approach. And I think maybe only because of the fact that we haven't, for other reasons, had successful federal privacy or AI law in the US, we are seeing activity at the state level and at the agency level, which I think is really where we're seeing a lot of active value-added approaches being created in the US, is in the context of specific regulations for particular industries, for transportation, for finance, for healthcare. And these agencies with a more limited scope are approaching AI and what are the risks here and how can we identify, mitigate, and control those going forward. And I think that's going to be a really useful model as well. And it's probably not ever going to be all one or the other, but some of my thoughts on that.
A quick thing before I get to you, Omer. I just wanted to raise something because it raised something about a very early debate in internet law. In the early days of the internet, there was a big discussion
the law of the horse.
About the law of the horse, right?
Yeah.
We have a separate law for the internet, or is the internet just going to pervade everything? What we saw is, in fact, the internet does pervade everything. And so if AI is going to be mixed into everything, then it's, all these different laws dealing with AI, and have like a special law for AI might, not really work. Is that
You actually stole my thunder there, Dan, because I really think about this as a law of the horse type of situation. Of course, that was the provocation of Frank Easterbrook, who was a judge at the Seventh Circuit Court of Appeals and a professor at the University of Chicago. And the idea there is, do we need the law of the horse or a law of the internet, or do we actually have laws that control the internet? In that context, libel and defamation and privacy and others. I think at the end of the day, the United States, by and large, didn't go for a law of the horse, a law of the internet. It did have Section 230, of course, which is more of a hands-off type of law, and some aspects of the DMCA, but the decision was to go with existing laws. And I want to point in this respect to the interagency statement by the chair of the Federal Trade Commission, Lina Khan, together with officials from DOJ, CFPB, and the EEOC, the Equal Employment Opportunity Commission, last month, in April, actually. And if you look at that statement, it's pretty short and it's well worth a read, because their kind of bottom line message is that there certainly is no exemption. There's no AI exemption from existing United States law. And that means that the laws that apply, currently, for example, civil rights laws, Title VII, and, fair lending and housing laws, Title VII of the Civil Rights Act with respect to employment, they apply in the AI context as well. And FTC still has Section 5, which, as you said, Dan, has a common law of privacy and data security, and they have the Fair Credit Reporting Act, which applies to AI, and GLBA for financial data, and COPPA for kids access. And we have tort laws, and we have product liability laws, and we have IP laws, which are very relevant here. So I think it's a mistake to view this as some Wild West that's completely unregulated. Now, it's true that Europe has been sort of leading with an AI-specific law, the AI Act, which is taking form these very days. I think it's interesting to note that it's manifestly not a privacy law, or even it's divorced from a human rights discourse. I don't think the words rights or privacy even appear in the 250,000 word document. What it is a product liability law, it's a safety law, and it's based, as Brenda said, on sort of risk categories, with the highest risk categories being things like critical infrastructure, and very much not privacy issues. I think the caveat there is that, similar to the situation with the internet, which I started with, law of the horse, where Europe had a lot of laws, and is still legislating, the DSA, DMA, DGA, the Data Act, GDPR, of course, the e-commerce directive, a lot of internet laws, but not much internet, because the industry is, mostly in the United States. You don't want to end up in a situation where you have a lot of AI regulation, but no AI industry. So I think we need to tread carefully there and make sure that if we do craft a sector-specific law for AI, it doesn't stifle innovation and sort of the industry.
So generally, do you think, because I've generally thought, a kind of risk-based approach is the way to think about privacy. And so in a sense, what is being done with the AI Act is at least closer to the thing that I would have hoped would be an approach to looking at privacy issues, which is, if you have a good conception of harm, and one of the problems is, we have, I think, very, backwards and myopic views of harm in the US on privacy. But if we have the appropriate understanding of harm, that way makes the most sense to me. If you look at harm and risk of harm as the trigger point for when we want interventions, and a risk-based approach of the AI Act in the EU, appears to try to do that. Is that, maybe, almost like an amendment to privacy law, would supplement it with the appropriate mechanisms to address? Is it too broad? And it sort of, by looking at kind of essentially what could sweep into, all algorithms or all automation, what, I guess, if we don't do the EU AI Act, then what would we do? And I guess we'd have to start amending and addressing all sorts of other laws to work with AI, and that's one of the challenges. Anti-discrimination law is really no match for AI, which could readily work around various data points, various inputs. Say, hey, just don't use, race, don't use gender, don't use, these, forbidden discriminatory categories in your algorithm. The algorithms can still come out to the exact same results. So just kind of work around it with other data that correlates to it. So it becomes really tricky. So you have to, start going through like the entire body of law to start changing it all to fit. Or, the EU's approach is, well, let's just try to capture it all in one. And I just wonder, is this going to fail? Is this too broad, or is this a step in the right direction generally?
I mean, I think that the potentially happy medium there is the risk-based approach, but maybe without trying to encode sort of by fiat in advance what's going to be high risk or what's not. I would say I think the reason that EU AI does that is precisely for the reasons that Omer sort of said they weren't thinking about, which is that rights-based, values-based approach. The only reason you would say something is too high risk to even use, which is one of their categories, is because you think the potential harms, privacy or otherwise, are so significant that it's just not worth the benefits of the technology. So even if they're not using that word necessarily, it's a values-based judgment to say that risk is that high. You're basing it on what those risks are, what those harms are, and therefore it made that cut. So it's inherently in there, even if it's not vocabulary in there. But I think in the US, at least, one of the options we have is to look to, for example, the NIST AI risk management framework that they just published earlier this year, which is that risk-based approach, but rather than sort of preemptively saying certain categories of use, certain types of technology, certain applications or contexts, it's up to the governing body, whether that's a company or a municipality or a government, to assess that model in a model risk management framework based on the guidance, in this case, provided by the NIST framework, and document that and outline the harms, outline the potential mitigations, and then implement and monitor it as you're using this system under that sort of purview. This is a model that already exists in the US for model risk management in the financial services sector. It began after the housing and general recession of the housing crisis and general recession of the 2007-2008 time period. The Fed released something called SR 11.7 in, I think, 2011. And so there's a decade plus of history now of implementation of this model risk management framework of how to responsibly deal with models. That is any predictive analytic tool, which are obviously embedded throughout the financial industry, that is now being adapted for models that are AI based, models that are machine learning models. And it's not perfect. It's not a direct correlation. You can't just sort of pick it up and rubber stamp it into machine learning context, but it has a lot of good established accountability mechanisms, 3 lines of defense, these other kinds of controls that are built in, and that have some proven time under their belt that informs the NIST framework, other frameworks around the world, international standard setting bodies that are using the same or similar approaches, that will enable us to sort of use this risk-based assessment process, but allow more contextualization for either industry or particular company or particular types of data, and so on. So I think that is definitely one of the places that we see opportunity and how to responsibly value these models and assess them, and then move forward.
I think there is, definitely room for targeted regulation. Although I have to say, like, kind of proposing an AI framework is really above my pay grade, and in a way, that's the point I'm making. In fact, Brenda here is the AI lawyer, and I'm just a lowly privacy lawyer. So, and I don't mean to say that I should stay in my lane. I think that's the other topic that you wanted to discuss then, like whether privacy people should kind of grab more turf right now. But I do think that some of these issues are just outside my area of expertise, because if you talk about completely banning the development of technologies, realize that we're talking mainly about EU and the US, but there are other places and countries in the world. And China, for example, is very advanced on AI technologies. And, if you think of nuclear non-proliferation, like one of the reasons or the reason that the United States developed nuclear weapons in the first place was because the other alternative would have been that Hitler would have them. So I think, it's difficult to ban technologies in a global context where, they could sort of emerge in different places. But having said that, some of the main players in this ecosystem, including OpenAI itself and Microsoft, and I think President Biden opined on it, that there should be even a licensing regime for some very high-risk technologies. So I think we're all in agreement about that.
Yeah, I think that's a real challenge. Is AI could cause some pretty bad things, and we generally, especially in the U.S., the model is do what you will until you cause harm, and then we will step in. The one challenge, though, is sometimes it could be too late. It could be too late by the time you've created it and unleashed it upon the world. It might not be something you can then just shut down or walk back later. But I think a kind of a licensing regime is something, when it comes to especially technology, fairly not very popular in the U.S. For how U.S. makes policy, which is typically the other way around. Everything's permitted until it kills you, and then it's too late, which is probably going to be the story with AI. But that at least that's in the future yet.
By the way, Dan, even if it kills you, I think other things kill you as well. So if you think of autonomous vehicles, for example, more than 40,000 people die every year from car accidents. And, at the same time, when there was a single incident where an autonomous vehicle hit a passenger, which is, awful, of course, and terrible, and I lament that, but the autonomous vehicle was kind of judged against the baseline of 0. So I think we need to keep that in mind as well. What's the baseline that we are comparing these risks to? If it's some utopian world where there are no risks, then certainly, we will outlaw most AIs. But if it's an imperfect world where, credit officers used to discriminate based on the person sitting in front of them. And that's why, we adopted the credit reporting system in the first place, not to generate or to cement discrimination, but to fight against discrimination that was very much a human, weakness and failure. Then I think kind of that balances the equation, and I think then it's more difficult to sort of reach decisions about not allowing autonomous vehicles because they can kill people. People get killed in many different ways.
I want to push back just a little bit on that. I agree generally, but I think that I often hear this argument made a lot with the use of algorithms to make decisions about people. It's like, well, the humans are terrible. The humans are biased and they're totally opaque, and therefore, we should go to the algorithms, which are going to be better. And it sets up a little bit of a false dichotomy because humans are so awful. Almost anything is better than a human. The problem is that the algorithms are a lot more systematic. They are often thought of as objective or unbiased when in fact they are biased, and also they're thought of as autonomous, kind of autonomous when they're they really are or sort of automated when humans are kind of involved in selecting the data and devising the models, and humans are involved in all steps of the process, so they kind of cloak the human involvement. So there are some dangers of I think the argument certainly has some weight, but I fear that it's often made too much and too strongly. And then it always wins when you compare it to the awful human.
Maybe it should, because some of our historical systems are pretty awful. But no, I take your point. I agree, Dan, and I'm sort of glad we were escalating pretty quickly there. I'm sort of glad we pulled back to some sort of very particularized applications and uses, because I think we also are able to distinguish that using certain kinds of AI or developing certain technologies that incorporate machine learning technology, which is a much more precise way to say it than sort of unleashing AI on the world, as it were, is something that we can make responsible choices about. So there are gradations of these things. We can maybe not allow a very quick progression of autonomous vehicles for individuals in terms of private cars, but we could, in fact, we are finding that autonomous vehicles in terms of, for example, shuttles and buses actually work pretty well because they run the same route the same way every day, and that's something that AI systems are pretty good at, and they may actually do it better than human drivers over time with not zero defects, because as we've said, everything has some defects, machine or man, but the improvement may be recognizable and significant and worthwhile, whereas in the sort of unrestricted set of personal choices somebody makes with their own vehicle, we may not be ready for that yet. And likewise, where there are things that we can use it to the more systematically track and evaluate and look at how the outputs are coming, and sort of as black box as some AI systems are, they're not nearly as black box as people tend to be. And so if we can, for example, there are people, and this is, I think, a very highly fraught use case for AI, is in the criminal justice system in any capacity whatsoever. But part of the reason it's so fraught is because we know our criminal justice system is so biased and problematic already. And so the data that we have to go on is very risky, and it's just very difficult to do. And of course, it's a very high risk stakes environment because of people's individual liberties and freedom. So if we're going to use any kind of tracking system to predict or recommend sentencing guidelines or bail opportunities or things like that, there's definitely not going to be a perfect system. Maybe some of the AI systems will allow us to actually see into the process, track that, make adjustments and changes more quickly. Maybe not, but they might at least give more transparency in a way that allows us to do better evaluations moving forward, because we certainly need to fix something, because we don't have very good success at where we are now. And I know there's a lot of advocates and people who are just saying don't use it at all in those contexts. And I understand that completely, because certain groups of people are already so much more at risk in those systems because of the inherited bias and the historical bias. But I like to think maybe there's a way we can actually do it in a way that gives us opportunity there for what the machines can do well in terms of tracking and predictive analysis, because we can actually look in and replicate those decisions better than we can for the people who've been doing it in the past.
Look, due process is a constitutional principle, and I think it obviously should apply in this context. And in fact, our friend Daniel Citron wrote a paper about algorithmic due process more than a decade ago, telling us that this is coming, that we should apply the same principles of transparency and the ability to appeal and to challenge and to know what the factors are in decision making, and certainly to eliminate any bias or discrimination. And again, I want to point back to the statement of the agencies of Lina Khan and Rohit Chopra and officials from DOJ and EEOC, saying there is no AI exemption from US law. The Civil Rights Act and the fair lending laws and all that, they apply to AIs, and AIs can't discriminate, full stop.
So I want to shift gears a little bit and talk about privacy officers and data protection officers. In the early days, privacy officers were, picked out if someone's walking down the hallway and it's like, you're going to handle privacy at this organization. And they were given this role. And now we have quite a lot of privacy professionals. I think IPP is now at 75,000 or 70,000 members, even higher. 80,000 members. Oh my gosh. And it's growing and it's growing. And there's so many around the world. One issue is, should they be tasked with dealing with AI issues? And I think there's kind of two components of that. One, should they want it and seek it out? And two, are they just going to get it whether they like it or not? Because companies don't want to hire a new person and they're the person that deals with any kind of ethical issues of data are just going to be thrown into the lap of the CPO or DPO. So kind of what do you think is going to happen? What should the response of privacy officers be? IPP is leaned in, which is actually what sparked your post, Omer, is that IPP starts to say, hey, yeah, we want AI, give it to us. Is that what privacy officers should invite that, or should there be someone separate to address this internally at organizations?
I mean, I think one of the reasons IPP has leaned into this, and I'm not representing them by saying this. This is just I think something I've heard or understood from conversations, is that they did a survey and found that in fact, some very large 60+% of privacy officers are being asked to take on AI governance responsibilities, or to start the AI ball rolling in their company, or to become the person who gets the extra knowledge, sort of with the understanding that they're not necessarily yet prepped for it, but that they probably, as we go back to the beginning of the conversation, have some of the background and approach and knowledge that will apply or be useful for that. And to be able to do that. And so, the fact is they're being asked to do it, whether objectively or ideally they're the right person or not. And so, IAPP, among others, is trying to put together a set of resources and tools to enable them to do that. And I think that's just the facts on the ground, is that's where things are going to go. It's not the only place that it could land, but it's definitely a starting point at many places and in many companies. The alternative, or an alternative, is, as I mentioned before, in the places that have, which is mostly the financial sector, have a background with model risk management. That actually includes something called a chief risk management officer. So there's somebody whose sort of whole job and focus is on risk assessment and risk basis of the tools being used by whatever the particular company or organization is. And that's another way for places that already have that sort of approach. But that's probably, I think, much less common than places that have a chief privacy officer or a privacy function. And that's, that's where people are looking.
First of all, to be clear, I applauded the IPP for stepping into the space, even in the post that you're referring to. And I think it's great and essential for the IPP and in general for organizations that work with privacy professionals to educate about this and maybe even to advocate if they have a position. With respect to the organizational sort of task and who owns it, I think sort of going back to what we started with, it depends, it depends what we're talking about. And if we're talking about an autonomous vehicle company, which is an AI, and you're talking about who should be responsible about AI there and about AI safety and relationships with NHTSA, I don't think it makes sense to have the privacy officer do it. If you talk about, again, risks of climate change, that's not a privacy officer thing. And, if your point is that they'll just get tasked with it, then maybe it's not a good result. It's like saying that, like, a patient needs brain surgery and there's no brain surgeon, so let the orthopedic surgeon do it. I don't want to go to that hospital. I do think that with respect to, PII and who handles personal information in the context of AI, that's definitely the privacy officers. And I also think that privacy officers in organizations have experience with applying legal and ethical rules to new technologies and to organizational processes better than perhaps other professionals, including even, for example, IP professionals, despite this issue also having very strong IP elements. So I do think that privacy officers are well placed to govern some of this, especially in the context of data and personal data. And this might be an opportunity for some of them, at least, to expand their portfolio and their role.
Yeah, I think that's right, because I think that ultimately what the privacy officer is often, one of the few folks at an organization who's more steeped in the humanities, who really understands and works with how to apply law and ethics to technology. That might not be the only, there's obviously more to addressing this problem than just that. There's, folks that are, need to be skilled in risk management and also technology. I think you really need to have a good handle on technology as well as, just the basic, scientific method of approaching this so that, AI doesn't turn into some kind of a pseudoscience. But at organizations, you often, especially tech companies, there are only a few people who are really come from a more of a humanities background, and that typically is the privacy officer, whereas a lot of others are not really trained in thinking about the humanities type of issues. And that's why I think a humanities background is really essential here. It really is needed. So there's a role for the privacy officer, but I think it might be too much to expect the privacy officer to handle every single dimension of this problem. But I think certainly should be involved unless there are others who have that kind of a background, that body of knowledge. And so making a generalization that the privacy officer more than other roles at a company is likely to have that kind of a background and that kind of thinking, which is really important to apply to this.
I'll just point out then that it's not just humanities. Like the EU AI Act has very little humanities in it. It's mostly STEM. And data scientists, I think, serve a very important role in debugging some of these systems and algorithms, and including testing them for bias and discrimination. So I think humanities is important, but you always want to keep the scientist, the mathematician, the engineer at hand.
This is basically the same thing I think I said at the beginning, which was that privacy professionals are one of the ones most likely to have the experience of dealing with data and technology applications from a variety of regulatory models and falling back on a core set of principles. And I know that that can be used for other contexts, but obviously what I meant, and I think what you both just said in this case, is it's a very similar set of principles, applicable jurisdictions, and use cases in many cases, not exclusively. Certainly there are physical safety and other aspects of AI beyond that. But in the same way that a privacy officer is not, in fact, responsible for everything about privacy. They are the chief privacy officer, but they have to work with the IT people. They have to work with the design people. They have to work with the marketing and sales people, and many others. Whoever is going to be running point for AI is going to have a similar set of principles around transparency and data quality and security and accountability and a lot of the very same things that a privacy officer looks for, but in a slightly varied application, now looking at the technology systems themselves and what particular AI or machine learning based models they're using. And again, what the perhaps slightly different take on the harms or implications of those might be, but it is that same sort of mindset and approach. And absolutely, they will need a team of people and adequate resources to do it. I don't think there's anybody anywhere who would jump in the mix here and say that even with additional training or understanding of AI, that they could do it all. They're going to have the support of the team and the upper management and everybody else to make that happen.
Well, I think that's a wonderful point to end on. I do want to actually add just one little additional point, which is I think that, in education and the way we train people, the way we train lawyers is sometimes siloed, and we don't do a good enough job really teaching them about technology and science. On the flip side, for technologists, their education often does not incorporate enough of the humanities and ethics and other things. And so I think it's important if we break down more of these silos, because this problem in particular really demands an understanding of both these bodies of knowledge to work well. And, that is why, it is helpful to have different people in the organization who have expertise in these areas, but it also would be great if everybody, no matter what their area, has a good working knowledge of these other areas, at least enough to be dangerous, so that they are not totally just reliant on like the one person who happens to know about this or that they all have some background in it. I think it's important, especially given given the reality today. And it's a challenge because, that there is so much to learn in each of these areas. But, it's important to know, even more broadly, some of the other things as well. So I hope that in education, we do a better job of more fully training people for the world to come. So with that, I just want to thank both of you so much for this discussion. I'd love to go on for another hour, but we're going to have to stop so that folks can go back to their work this afternoon. So thank you both for joining me, and thanks to our audience for joining us, and have a great rest of the afternoon.
Then if I could just acknowledge that there is like a debate and a discussion raging in the comments section, and I look forward to reading all of this. It looks like a whole literature, actually. So people are, obviously super engaged and interested in this, and I look forward to continuing some of these discussions on and offline. So thank you for hosting, and thank you, Brenda. Always a pleasure.
Thanks to both of you. Great discussion.